Everyone, this is Politics Tonight. Thank you for joining us on the program. I am Olajumoke Olatunji. President Bola Tinubu signs 54.99 trillion naira 2025 appropriation bill into law. Tonight we'll be speaking with Valentine Osigbo, an APC governorship aspirant, to know why he dumped the Labour Party for the All Progressives Congress. Welcome to the program, everyone. Stay with us. I'll be right back. Welcome back, everyone. Now let's begin with some political developments. President Bola Tinubu has signed the 54.99 trillion naira 2025 appropriation bill into law, marking a 99.96% increase from the 2024 budget of 27.5 trillion naira. The budget was signed during a brief ceremony earlier today in the president's office. The bill was approved by the National Assembly on the 13th of February after revisions to President Tinubu's initial budget proposal of 49.7 trillion naira. A key breakdown of the 2025 budget includes a total expenditure of 54.99 trillion naira, statutory transfers of 3.65 trillion naira, and a recurrent expenditure of 13.64 trillion naira. This increase reflects additional anticipated revenues from agencies such as the Federal Inland Revenue Service and the Niger Customs Service. The Supreme Court has ordered the Central Bank of Nigeria and the Accountant General of the Federation to stop further release of financial allocations to Rivers State governments with immediate effect. The Apex Court directed that the order shall be enforced until the governor of Rivers State, Siminalayi Fubara, stops all his illegal, unlawful and unconstitutional activities. Celestina Area reports.
The court said that no money shall be released to the state government until a lawful appropriation law is enacted under the Martin Amerule-led House of Assembly. In a lead judgment delivered by Justice Emmanuel Alguim, the Supreme Court also ordered the 27 members of Rivers State House of Assembly to resume duty immediately. The unanimous judgment of the 5-member panel of justices, led by Justice Owani Abaoji, faulted all actions carried out by Governor Fubara for being unlawful. The Apex Court took a swipe at the governor for engaging in criminal activities of demolishing the House of Assembly with impunity just to prevent 27 legislators in the House of Assembly from sitting to carry out lawful activities. Justice Alguim ordered the clerk and deputy clerk, which were unlawfully redeployed out of the House of Assembly, must be allowed to resume work alongside the House of Assembly workers. The court held that it was an aberration for Governor Fubara to operate with only 4 out of the 32 House of Assembly members under the guise of baseless fears that he would be impeached. According to the justices, Governor Fubara, by his unlawful acts amongst others, collapsed the House of Assembly and used his immunity under Section 308 of the Constitution to carry out unlawful acts against the rule of law. A sum of 10 million naira fine was imposed on Governor Fubara to be paid to the House of Assembly and the 27 members who instituted the suit against him. In another judgment, the Supreme Court invalidated the local government election conducted in Rivers State on 5th October 2024. The Apex Court held that the election was invalid because all conditions precedent that should have been implemented were jettisoned by the Rivers State Electoral Commission. Specifically, Justice Jamil Utuku, who delivered the lead judgment, held that the council poll was conducted in gross violation of Section 150 of the Electoral Act of 2022.
It has come to show us that all the political caricature in Rivers State must come to an end by this judicial decision. It has come to confirm that the only valid member of the House of Assembly are the 27 members under the leadership of Martins Amehuli. It has also come to confirm today that there has been no government in Rivers State all this while, because the 3 arms of government must work together effectively. For the past 1.5 years, the Rivers State House of Assembly, which is an arm of the government, has been set aside. The implications are real. All the appointments confirmed by the House of Assembly all the laws passed, all the budget passed are invalid. That's the essence of this election.
A member of the Apex Court Justices who delivered judgment in their appeal in respect to the conduct of local government election, Justice Emmanuel Aogim, said there is a new trend by the court to ensure the promotion of the observance of the Constitution and the rule of law. When there's a violation of the Constitution or the rule of law, the courts will not look the other way. Celestina Iria, TVC News, Abuja.
And later on the show, we'll come back to those political developments in Rivers State. Away from that, Justice Yetunde Fihero of the High Court of Lagos State is adjourned to March 7, 2025 to hear all pending applications brought by various counsel in a suit filed by removed Speaker of the Lagos State House of Assembly, Mudashiru Obasa. His removal on January 13, 2025, which he is challenging, follows allegation of gross misconduct and abuse of office that led to his deputy, Mojisola Miranda, being elected and sworn in as his successor. Kemi Foladeyemo has more.
Friday's hearing is the first sitting by a court of law in the battle for the legitimate leadership of the Lagos House of Assembly. A senior advocate of Nigeria, Afolabi Fashanu, represented Mudashiru Obasa. The defendants in the suit are Mojisola Miranda, who was represented by lead senior advocates Tayo Yetibo and Abimbola Akeredolu. The House of Assembly, another defendant, was represented by two senior advocates, Femi Falano and Muiz Banire. But another counsel, Abang Pandiok, announced appearance for the House of Assembly, saying he had been briefed on Thursday night and had filed his motion for a change of counsel on Friday morning. He asked the court to hear his application first, saying it was a fundamental issue that deals with a person's constitutional rights to a counsel of choice. But Mr. Falano rejected the claim, saying he remains the counsel on record and that he hadn't even been served with that motion. The court deferred hearing Mr. Pandiok's application pending compliance with the rules of court, since he had admitted that all parties hadn't been served with his processes. After the proceedings, Mrs. Miranda told journalists she was still in charge, even though her security detail had yet to be fully restored.
I have, I think, 3 or 4 policemen, whereas my normal convoy, my team, 12 policemen, 4 DSS and 2 anti-bob. But as I have it this morning, I don't have that. The removed speaker. Well, I think he's still a member of the House of Assembly, so he has every right to come. But invasion and breaking into my office, that is really a big one. In our job, we have numbers that form quorum. So if you are sitting with 3 or 4 members, you're only doing theater.
We are still committed to our leadership, and we are still committed to serving the people of Lagos State. And that is what is more important.
Justice Pinheiro says she is conversant with the facts of this case and has given a strict timeline within which the various counsel in this matter file and exchange court processes ahead of the next adjourned date. The court added that any lawyer that doesn't follow the timeline she has given will be deemed to have waived his or her right to do so. Kemi Foladeyemo, TVC News.